Good day, everyone. So, we are the Group 2 and we are going to report about Article 13, Mitigating Circumstances. And the first reporter is me, to be followed by Raymond Vancy, and then Tristan Anki, and the last one is Jeric Bakuwak. So, we hope that you will learn a lot from our report. So, I will going to start the report. Our topic learning objectives is that this topic reports aims to further discuss the Article 13 mitigating circumstances and its receding factor. And our sequence of our presentation is first is the definition, followed by bases, classes, distinctions, and mitigating circumstances. Introduction. The objective of this report is to give the listener an overview of the Article 13 mitigating circumstances that will be presented and to do further increase our knowledge about this article. So the definition of Article 13 mitigating circumstances are those which, if present in the commission of crimes, do not entirely free from the actor from criminal liability, but serve only to reduce the penalty, which is means that to reduce your penalty. The basis. Based on the diminution of either freedom of action, intelligence, or intent, or in the lesser perversity of offender. So we have two kinds of mitigating circumstances, which are first is the ordinary mitigating circumstances. Um, ordinary ordinary circumstances can be offset by aggravating circumstances, and the second kinds of mitigating circumstances is the privilege mitigating circumstances. Privilege mitigating circumstances is a circumstances cannot be offset by aggravating circumstances. Article 68. Penalty to be imposed upon a person under 18 years of age. Upon a person under 15 but over 9, that he act with discernment, a discretionary penalty always to 2 degree lower. Upon a person over 15 and under 18, penalty next lower than that prescribed by law. Article 69. Penalty to be imposed when the crime committed is not fully excusable. Penalty lower by 1 or 2 degree. Article 64. Rules of application of penalties, which contains 3 periods. Privilege mitigating circumstances applicable only to a particular crimes. Voluntary release of a person illegally detained in 3 days without of offender attaining the purpose of before the institution of crimes action. Penalty is 1 degree lower. Article 6, 268, Part 3. Abandonment without justification of the spouse who committed adultery. Penalty is 1 degree lower. So we have here the extensions. As you can see, there is a graph. Um, ordinary mitigating circumstances and the privilege mitigating circumstances. So, in ordinary mitigating circumstances, offset offset by any aggravating circumstances produces only in the effect of applying the penalty provided by law for the crime and its minimum period in case of divisible penalty, while privilege mitigating circumstances cannot be offset by aggravating circumstances produces produces the effect of imposing upon the offender the penalty lower by 1 or 2 degrees than that provided by the law of crime. So we have 10 mitigating circumstances. So first, those who mentioned in the in all requisites necessary to be justified the act or the exempt from criminal liability in a respective case are not attendant. Incomplete incomplete self-defense. Defense of relativeness, relatives and defense of stranger. First requisite is present but the other two are not. Incomplete justifying circumstances of avoidance of greater evil or injury. The last two requisites are not present. Incomplete justifying circumstances are perform, performance of duty. Incom- Incomplete justifying circumstances of obedience to an order. So the next reporter will give you further discussion about the mitigating circumstances. So it's your turn, Raymond Bansi.
Thank you so much for that, buddy. Number two, Paligog, next one. Number two, that the offender is under 18 years of age or over 70. In the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80, Article 192, Presidential Decree number 603. Basis: based on the diminution of intelligence, a condition of voluntariness, contemplates the following: an offender over 9 but under the age of 15 who acted with discernment, an offender over 15 and under 18. 1. Upon the person under 15 but over 9 years of age who is not exempt from liability by reason of the court having declared that he acted with discernment, a discretionary penalty shall be imposed, but always lower than by 2 degrees at least than that prescribed by law for the crime which he or she committed. Upon a person over 15 and under 18, the penalty next lower than the prescribed by law shall be imposed, but always in the proper period. Requisites: that the minor must be tried in accordance with the provisions of the Article 192 Presidential Decree 603. That after trial, the minor was found guilty and committed to the custody of a reformatory institution or to custody of a responsible person, and that the minor became incorrigible while in the reformatory institution or while in the custody of a person, an offender over 70 years of age. In the case of a minor, he shall be proceeded again against in accordance with the provision of Article 196, 192 Presidential Decree number 603. In the apprehension of minor, he or she shall be proceeded with Article 192 Presidential Decree number 603, suspension of sentence and commitment of youthful offender, which states that the court shall suspend all further proceedings and shall commit such minor to the custody or care of the Department of Social Welfare Development until he or she shall have reached 21 years of age or for a shorter period as the court may deem proper. Another one is that when a minor has committed an offense punishable by death, penalty shall not be imposed, and if death penalty is already imposed, it shall be suspended and come to a halt. Legal effects of various ages of offender. Under 9 years of age, exempting circumstances. Over 9 and under 15, he acted without discernment, exempting circumstances. Minor delinquent under 18, sentence may be suspended. Under 18, privilege mitigating circumstance. 18 years and above, full criminal responsibility. 70 or over, mitigating circumstances. Number 3, that the offender had no intention to commit so grave a wrong as that committed. Rule. This circumstance can be taken into account only when the facts proven show that there is a notable and evident disproportion between the means employed to execute the criminal act and its consequences. Basis. Intent element of voluntariness in intentional felony is diminished. Intention and act is judged not only by the proportion of the means employed by him to the evil produced by his act, but also by the fact that the blow was or was not aimed at a vital part of the body. Number 4. That sufficient provocation or threat on the part of the offended party immediately preceded the act. Provocation. This means that any unjust or improper conduct or act of the offended party capable of exciting, enticing, or irritating anyone. Requisites. That the provocation must be sufficient. Sufficient means adequate to excite a person to commit the wrong and must accordingly be proportionate to its gravity. You need the provocation to be sufficient in order to determine its gravity. Number 2, that it must be originate from the offended party. Number 3, that the provocation must be immediate to the act, to the commission of the crime by the person who is provoked. Note that threat is immediately preceded the act. The threat should not be offensive and positively strong because if it is, the threat to inflict real injury is an unlawful aggression which may give rise to self-defense. Number 5 should be followed by my body.
So number 5. The act was committed in the immediate vindication of a great offense to the one committing the felony, his spouse, ascendants, descendants, legitimate, natural or adoptive brothers or sister, or relatives by affinity within the same degree. Requisites that there be a grave offense done to the one committing this felony, his spouse, ascendants, descendants, legitimate, natural or adoptive brothers or sisters, or relative by affinity within the same degree. Number 2. That the felony is committed in vindication of such a grave offense. Gravity of the offense means the gravity of the underlying crime committed by the convict person subordinates. Basis to determine the gravity of offense in vindication. 1. Social standing of the person. 2. Place. 3. Time the insult was made. Number 6. That of having acted upon impulse of powerful as naturally to have produced passion of or obfuscation. Passion or obfuscation means may constitute mitigating circumstances only when the same arose from law sentiments basis. Loss of reason and self-control because of excitement, thereby diminishing the exercise of his willpower. Rule. Passion or obfuscation may constitute mitigating circumstances only when the same arose from low sentiments. For this reason, even if there is actually passion or obfuscation on the part of the offender, there is no mitigating circumstances when 1. That the act is committed in a spirit of lawlessness. 2. The act is committed in the spirit of revenge. Notes: it is necessary that the act which give rise to obfuscation will be not removed from the commission of the offense by a considerable length of time, during which period of per- perpetrator might recover his equanimity. 7. That the offender had voluntarily surrendered himself to a person in authority or his agent, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. These are two mitigating circumstances are provided in this paragraph. 1. Voluntarily surrender to a person in authority of his agent. 2. Voluntary confession of guilt before the court prior to the presentation of the evidence for the prosecution. Person in authority, member of some court, government, corporation, or board or commission. Agents of person in authority has direct provision of law or by election by appointment by competent, is charged with the maintenance of public order and protection and security of life and property and any person who comes aid with the authority. Article 365 Part 5. Penalties for culpable felonies. In the imposition of these penalties, the court shall exercise their sound discretion without regard to the rules prescribed in Article 64. The next reporter is my buddy.
Okay. Number 8. That the offender is deaf, dumb, blind, or otherwise suffering some physical defect which does restrict his means of action, defense, or communication with his fellow beings. There are physical defects being armless, crippled, or a stature whereby his means to act, define himself, or communicate with his fellow beings are limited. The code considers educated and uneducated, deaf, mute, or blind persons as being on equal footing. Number 9. Number 9. Such illness of the offender would thus diminish the exercise of the willpower of the offender without, however, depriving him of the unconsciousness of his act. There are bases dimi, diminution of intelligence and intent requisites. One, that the illness of the offender must diminish that exercise of this willpower. Two, that such illness should not deprive the offender of consciousness of his acts. When the offender completely loses the exercise of willpower, it may be a exempting circumstances illness of the mind, which refers the disease of pathological state that trouble the conscience and will, and not amounting the insanity may give place to mitigation. Number 10. And finally, any other circumstances of a similar nature or analogous to those above mentioned. Mitigating circumstances which are personal to the offenders. First, from the moral attributes of the offender or from his private relations which the offender party or from any other person cause shall only serve to mitigate the liability of the part of the principals, accomplices, and accessories as to whom such circumstances are attendant. Circumstances which are neither 1. Mistake in the blow aberratia ictus Article 48 complex crime committed. 2. Mistake in the identity Article 29. 3. Entrapment of the 4. The accused is over 18 years of age. 5. Performance righteous action. Thank you, Bade.
Conclusion. Under the Article 13 of the Revised Penal Code, mitigating circumstances are those circumstances which, if present in the commission of crime, do not entirely free the actor from criminal liability, but serve only to reduce the penalty. That would be all our contents for this report. Thank you.